I'm going to get started, Rob. All right, everybody, welcome to this Zaremski lecture. We are very grateful to Miles and Elena Zaremski for funding this programming and for our lunches. Our speaker today is Professor Rob Gatter. He is a professor and the director of the Center for Health Law Studies at St. Louis University School of Law. Professor Gatter holds a bachelor's degree from Johns Hopkins University, a JD from the University of Pennsylvania Law School, and a master's degree in bioethics from the Medical College of Wisconsin. Among his areas of expertise are public health law, informed consent, end-of-life decisions, conflicts of interest, and more. His work has appeared in many very prestigious law journals. He has won teaching awards, and he has set up several important programs at his university. We are delighted to have Professor Gatter with us today, and his very timely lecture is entitled The Rollback of Public Health Emergency Powers and a New Model Law.
Well, thank you, everybody, for being here. I want to start by saying that I'm a big fan of all the faculty at Case Western's health law program. We know each other well. Thank you, Max and Sharona, and for making this possible. Thank you to Patty for her help in getting this organized and me organized. And I should thank the Zaremskis as well for this. It's important to have these kinds of exchanges. So hello to the students, hello to the faculty and staff, hello to everybody joining in on the webinar. I'm excited to present this to you because it is so timely. And what I'm going to do is walk you through the sort of the landscape of where we are. And then I'm going to turn to something that is a project that I've been working on for the last year and a half or so, and will come to an end in late July. It's the development of a model Public Health Emergency Authorities Act, which is being done through the Uniform Law Commission. So more on that as we go. I'll be sure to leave plenty of time for questions at the end. So I start off with this quote about public health practice, and that it relies on the cooperation of individuals and communities, and that it requires trust. There's very timely information today in the Washington Post. There's an op-ed from the former City of Baltimore public health official. There's also a Health Affairs. The most recent issue of Health Affairs has an article about this exact issue by Michelle Mello and Larry Gostin. And they both emphasize trust and the relationship between trust, transparency, and accountability, in addition to other factors. So what we've seen happen is that, and you've experienced this, as the population becomes frustrated with COVID orders, with public health orders that last for a considerable period of time and influence their lives, whether it's a mask or whether it's an employment requirement to get a vaccination, or it's a limitation on the number of people who gather, or businesses as they're being open or closed. They get frustrated with this. They get frustrated with the emergency health orders. And then when they do, they take action, which tends to undercut the statutory authority of executive branch officials to issue orders at all. My triangle there, right, says, well, there's the authorizing statute. That's the base, right? That's where the legal authority comes from. At the next level up, it says declaration. Under most emergency management statutes, including public health emergency statutes, the governor is authorized to declare an emergency, in this case, a public health emergency. And having done so, the authorizing statute then says, while the declaration is in effect, the governor and those to whom the governor might delegate inside of the executive branch the power to do so can issue orders. And those are the orders that we're talking about as people become more frustrated with them. When that frustration takes aim at the authorizing statute, you can see that it undercuts the base of this triangle, because without that authorizing statute, the declarations are not possible and the orders are not possible. Instead, it's probably better to be taking aim at challenging the orders or the declaration, where you're concerned that doesn't have legal authority. But instead, we've seen attacks primarily at the authorizing statutes themselves, and I will address some of those. What we have seen as frustration mounts is what Jill Kruger of the Network for Public Health Law calls the burn it all down fervor, sort of the mentality that I'm upset with the ongoing pandemic. I think the government has overreacted, or I'm just frustrated and tired of dealing with whatever governmental orders are in place. And so I simply begin to reject them. And if the governor won't do so, if the state public health officials won't do so, then we'll take aim at their authority to issue any orders whatsoever. So there was a lot of litigation. Over 1,100 cases were decided, state and federal level, primarily at the state level. And they addressed a variety of issues, but generally they tended to attack the authority of a governor to act under an authorizing statute. Sometimes they would be separation of powers arguments, such as non-delegation and major questions doctrines. Sometimes they just took aim and raised statutory construction questions about how to interpret the word necessary in some of those statutes, which I'll take the time to explain now. Almost all states, I would say all states, provide authority for executive branch officials to take whatever action is reasonably necessary to prevent an infectious disease from entering the state or to prevent the spread of an infectious disease. There are other statutes that exist that might specifically talk about quarantine, or those statutes might talk about quarantine and isolation. And there are probably also additional statutes that discuss the responsibility of state public health officials to be monitoring for various diseases, making reports to the governor and to the legislature, et cetera. But they generally have this very broad language about taking what action is necessary in order to protect public health. And so some of the litigation has been aimed at identifying, at narrowing the what constitutes necessary in those instances. And then there is a problem with the fact that a mass order, for those of you who have taken administrative law or you're taking administrative law, you might start to recognize this problem. When a governor issues an order that says everyone in the state must, let's say, stay at home, that is a single order that applies to many, many different people. In administrative law terms, that's a rule, even though it's captioned as an order. An order is an administrative action that's aimed at generally one person, sometimes one small group of people. And rules set standards that are applicable to a general audience. And so certainly countywide, citywide, statewide public health orders, even during an emergency, would constitute rules. And if they constitute rules, then they are subject to administrative rulemaking, standard rulemaking, or even emergency rulemaking, which is a slower process. Even emergency rulemaking doesn't take effect immediately in almost every state. And there are certain checks, such as rule review, that state legislatures often have in place that may also apply during emergency rulemaking. So when the litigation aims at those, it tends to slow down the ability of the governor or executive branch officials to respond quickly. And as you recall from the current pandemic, early on, with every passing day, we were watching numbers increase geometrically because of the spread of the disease was so easily spread. Now, before I move on from this, the vast majority of these 1,100 cases that were brought and challenged state authority were resolved in favor of the state. So it's not that across the board, or even 50% of the time, we were finding that state court judges were invalidating public health orders or public health statutes or inappropriately narrowing the definition of what was called necessary. But there was a substantial number who did so. And all it takes is one sort of ruling in a state at an appellate level to create a degree of uncertainty that's problematic for our preparedness for the next public health emergency. And you'll hear me talk about that quite a bit. Part of public health emergency preparedness is the preparedness of the law. It's not that we can ever prepare the law in such a way that there are no disputes and there are no lawsuits that are brought, but instead that we have at least tried to clarify the law as well as possible so that we minimize the degree of uncertainty that there is going in. And as you'll see from what we try to do with this model law, that we have channeled then the challenges to individual orders or to the public health emergency declaration. In addition to litigation, there's also been more recently a number of legislative enactments that have substantially restricted the ability of executive branch officials to declare emergencies, to retain those emergency declarations in the case of a lengthy emergency, or to issue orders. And there's a number of ways that this has happened. One that I'll focus on here is bullet 2 under that statutory amendment heading, legislative vetoes. There are about 32 states where a legislative veto option existed as a matter of statute, either before COVID or more likely since then. And this is how those work. The governor can declare a public health emergency. The governor, with that public health emergency in hand, can issue orders. There are a number of new statutes that authorize the state legislature to unilaterally discontinue the declaration based upon a concurrent or joint legislative resolution. And that would say end the declaration. If it ends the declaration of public health emergency, if the emergency is over, then the governor's power to issue orders and any orders that were issued as a result of that extraordinary power, they also come to an end. And it also then limits the ability of the governor to declare the same emergency a short time later. The key here is that they're listed as legislative vetoes because although they require bicameral passage of the resolution, they don't require presentment of this resolution, otherwise what we would think of as a bill that's been jointly passed. They don't require presenting that to the governor for the governor's signature or veto, which would then create an opportunity for a legislative override. And this is something that is difficult to justify under most state constitutions, because most state constitutions, like the federal constitution, limits the ability of the legislative branch to make binding law to bicameral passage of a bill and presentment to the chief executive. And we've already seen that be problematic in at least one state during COVID. So in Pennsylvania, and actually, I think I'll advance forward on the slide and I'll get into it a little bit deeper, but I'm going to mention a Pennsylvania case that that declared that kind of statute to be unconstitutional because it failed the obligation of presentment. So the Model Public Health Emergency Authority Act, I've taken a picture of the front cover of the draft that was available for a meeting that we did about a month ago. It's no longer the current draft. I've been making changes to it. I am the reporter to this drafting committee, and we've been working for 2 years on a Public Health Emergency Authority Act that's designed to try to clarify what powers a governor has during a public health emergency, and to create better legislative accountability, better checks and balances, without potentially triggering a constitutional dilemma with respect to things like legislative vetoes. And I'm just going to check the chat here for a second. Yeah, so in the chat right now is a link All of the work of the drafting committee and all of the work of all drafting committees of the Uniform Law Commission is available publicly. If you'd like to, you can click there. If you're going to go there, you'll be in a folder of our last meeting, and there are a number of documents that are in there. One of which is called, and I think it's the second one on the list, called Clean Copy, and that's the one you'd want to download. You don't need to, I'm not going to be going through, let's start in section 1, then section 2, and so forth. I'll be jumping around a bit. I'm really giving an overview. So it's not necessary that you have this in front of you, and it might be a little frustrating as you're jumping around, but I encourage you to nonetheless download it because you may be interested after this talk in going through and reading it yourself and staying up to date with it as we go into the next round. We'll have another round of drafting in late March, and then that's really it. It goes into the Uniform Law Commission approval process, and I might as well talk about that now because I think that's my next slide. Yeah, so the Uniform Law Commission, an age-old venerable organization. It brought you hits like the Uniform Commercial Code, I know you're all very well aware of. And it operates today similarly. There are about 400 commissioners. The commissioners are come as representatives of individual states, much like members of the House of Representatives. They are appointed generally by a public or quasi-public process. It's not uncommon, for example, for governors of states to appoint the commissioners. The commissioners then work on a variety of projects. The leadership of the commission assigns them to, as voting members, to drafting committees or study committees. The commission moves slowly. It does not like to get too far out ahead of itself, and it's very careful about how it spends its resources. So this issue actually came up at the very start of the pandemic, whether or not a model law or a uniform law regarding mitigation powers of state executive officials made sense. And so the Uniform Law Commission started by creating a study committee. And for about 18 months, that group studied whether or not it was worth the resources for the commission to form a drafting committee. They decided to do so, although I will tell you that there was a dissenting viewpoint that it wasn't worth doing, not because this isn't an important area of law, but because it's such a hot button issue politically. The Uniform Law Commission is interested primarily in seeing whatever it invests its resources in, the payoff, the return on that investment is adoption. And the concern from some was that this is such a hot button issue that even if we draft this and its best practices, and it makes a lot of sense, that many states might not be interested in even holding a hearing on it because it's such a politically controversial issue. But in the end, the commission decided to go forward. We have a fairly narrow charge. It is to try to clarify the relationship between the executive and legislative branches with respect to public health emergency powers, and a little bit with respect to the powers of the state to preempt local law during a public health emergency. There were many other questions that were left off the table. And the logic of the Uniform Law Commission was that it's better for us to have something on the table and available for states, even if we don't see immediate adoption, because there will be public health emergencies in the future. And some of the rollback in public health emergency powers that we have seen may cause some states and some state legislators after the next crisis to rethink whether it's best to have to renew the authorizing statutes. And if so, it'll be good for us to have this in place. Additionally, this whole thing happens in the context of anti-government sentiment generally. The legislative organization known as ALEC that is generally prepares model state legislation for very conservative politicians that generally seek to remove authority from executive branches, limit government authority generally, and whatever government authority there is to put it in the legislative branch. ALEC has its own model law with respect to public health emergencies, one that has been largely adopted in Florida. And I think the Uniform Law Commission was saying that's not it's not a best practices based law. And as a result, it's good for us to have something on the shelf that is at least competition for what ALEC has put out. So for those reasons, the Uniform Law Commission went forward. Drafting is a 2-year process. Each July, the Uniform Law Commission has an annual meeting. All 400 members get together. At the July meeting at the end of the first year, the existing draft at that time was read to the 400 commissioners, and they were given an opportunity to respond on the floor live. We take that back to the drafting committee, and we try to improve the bill over the course of a second year. It's about to be locked down. I would say it will be locked down as of April 1st, and it begins a lengthy approval process inside of the Uniform Law Commission, culminating in the July 2023 annual meeting, at which time this model law will be put up for a second reading. And at that time, generally speaking, it's either approved by the Uniform Law Commission or it is not approved by the Uniform Law Commission. If it is adopted by the commission, then each state's commissioners develop a strategy to have the bill introduced in their home legislatures. So that's where we stand right now. You really are at the front edge of this. I was drafting a little yesterday. I'll be drafting again a little this afternoon. So this is a nice little break for me in the process. I've given some of you, I've given some background on this. Right, the basic structure of this statute is very similar to a previous public health emergency, a model law that was created in the wake of 9/11. It's not a Uniform Law Commission model law, but it's been fairly widely adopted. That the governor has the power to declare a public health emergency. That declaration then empowers the governor to issue public health orders. And this model Public Health Emergency Act is separate from other state emergency power statutes. It doesn't try to replace all of those. Instead, it's limited to public health emergencies. And I think the train derailment in Ohio is a good example of how state statutes might work together if this state were enacted in Ohio. A train derailment that can create an emergency in and of itself that wouldn't necessarily be a public health emergency. But then once we get to the stage where we know that there were dangerous toxins that were spilling out, leaking out, or having to be burned off, and there's concern about drinking water or air quality, then that portion of the emergency would be subject to this act because that portion of it is a public health emergency. So it's possible to identify emergencies in which more than one statute, a general state emergency management statute, as well as this public health emergency authorities statute, might both be triggered to deal with different parts of one emergency. Okay, this is the way I'm going to take you through the rest of this act. There are really 3 goals, and that's how I want to organize the rest of this presentation. Securing public health emergency powers, promoting accountability, and channeling legal challenges. Securing public health emergency powers was a key, and so that's really where we began. But accountability is where we really addressed the concerns about what about an active role for the legislature. So at the top of each of these slides, now you'll see that I've color coded them a bit. The darker blue that the title uses, the text of the title uses, that's the section that's about securing, then we're in the section that's about securing public health powers. So I had mentioned to you the broadly worded statutes about actions that are reasonable and necessary to protect public health. And there's risks and benefits with that. What's happened with litigation is that broadly worded statutes generally have been subject to limitation. And it's happened in a couple of ways. One is to say that when the legislature passes broad authority to the executive branch in vague terms, it may have violated the non-delegation doctrine, or it may have passed over to the executive branch some powers that don't involve major questions, but implicitly could involve major questions, and it cannot. So the idea, this is essentially a separation of powers argument. The legislature has to legislate. It can delegate authority to the governors, to the executive branch, to make regulations and so forth, but it must do so with some sort of intelligible principle. And the argument that has worked in, not in all states, but in several, has been to say that that's too much authority. It involves major questions when we're now talking about, say, this pandemic that has lasted for such a long time. Another way to attack it is to say there was no intelligible principle other than saying, do what's necessary to protect public health. Do whatever you have to do. And the argument was that that's too broad and too little guidance from the legislature, such that really the legislature has unconstitutionally passed its vested legislative authority to the executive branch. In Wisconsin, this worked, and it's not the only state. Another way to do this is to really just use challenge on the grounds of rules of statutory construction and say, well, what does reasonable and necessary mean? Let's read it in the context of other articles inside of this particular title of the state code. And what we find is that there may be other statutes that talk about surveillance of certain diseases. It may talk about contact tracing, quarantining individuals who've been exposed but are not yet showing symptoms, isolating people who are sick with a disease, a contagious disease, and are showing symptoms. It might talk about quarantining animals, culling herds of animals. It might talk about quarantining certain vegetation, etc. And the argument is that one tool of statutory construction is to read the broad language of reasonable and necessary to be limited by the more specific authorities that are also listed in neighboring state statutes on the same topic. And so there have been states to say reasonable and necessary really just means that you're limited to isolation, quarantine, surveillance, and contact tracing. It means using those when they're reasonable and when they're necessary. And that, of course, severely narrows it. The idea of a broadly worded statute is that it helps us deal with emergencies where it's difficult to imagine. And this brings us to an important point about this pandemic. Isolation and quarantine works well when you have an infectious disease that you can stop the spread of and prevent its taking root in a particular community, rather than when it has taken root. So, for example, it can work with tuberculosis. It was worthwhile, isolation was worthwhile when we were concerned about Ebola. But COVID was transmitted so easily that it really took hold, and it was not possible to quarantine and isolate everyone who was exposed or who became sick. And so as a result, that's not a very valuable tool. Instead, other kinds of tools that in the public health world are known as tools of mitigation, proved to be more helpful, separating individuals, wearing masks, holding some events outdoors, limiting the space between people, requiring stores to put up plexiglass in certain places, or to put arrows in their aisles so they became one way. These are all not designed to stop the disease from coming into a community, but instead they're designed to mitigate the effects of that disease once it's taken root. So if you only have a set of statutes that talk about quarantine and isolation and otherwise talk about reasonable and necessary, it's nice to be able to use that reasonable and necessary to say, well, anything that's necessary to prevent the spread of this disease, that would include things we've never done before. Closing schools, closing businesses, requiring masks, etc. But if you rely on the broadly worded statute, you take the risk that in litigation, it is narrowed for you or it is declared unconstitutional. And then it's of no use, right? If it doesn't exist or it's been narrowed, you can't use it for those mitigation tools. That takes us to the specifically worded statutes. The difficulty with specifically worded statutes is that you have to be able to imagine all the tools that you might want to use in the future. So our strategy now, but they're more likely to survive those same kinds of attacks. So our strategy has been to retain both the broadly worded power and to add specific categories of powers, while at the same time providing substantive principles and procedural guardrails for all public health emergency declarations and orders, hoping that they would count then as narrowing the authority enough and providing substantive guidance from the legislature so as that the broadly worded language would survive. And I'll have an example of that as we go forward. Well, here it is. The first one is that right now in our Public Health Emergency Act, there are about 20 specific purposes for which a governor may issue a public health emergency order. And a lot of those, while some of them are about are preventative in nature, and they include things like isolation and quarantine, they're largely about mitigation efforts. By putting those into a statute, we now no longer run the risk that mitigation tools wouldn't be available. At the same time, we have a separate provision that preserves the general power, but you'll see that its language provides some substantive guidance. The governor is empowered during a public health emergency to issue any order to eliminate or reduce any of the risks, sorry for the misspelling there, any of the risks of harm posed by the public health emergency, or to eliminate, reduce, contain, or mitigate any effects of the public health emergency. So that's more specific, right? The general power is there in the sense it says any order. But at the same time, the guidance is more than just that which is necessary to protect public health, that which is necessary to prevent the spread. At the same time, another section requires that each order has to be rationally designed to achieve one or more of the goals that are listed in that description of the general power. And that acts as both a substantive and procedural safeguard. Additionally, before issuing an order, the governor has to account for 6 different factors, and those factors include things like what's the evidence available then that the actions of the governor in the order are likely to have the effect of achieving the goal of either reducing a risk or mitigating effects. It requires assessing vulnerable populations and whether the benefits and the burdens are equitably distributed. It also requires considering the economic effects, the likely economic effects. So there's a variety of 6 factors. These 6 factors also then operate as providing additional substantive guidance. These are the considerations the governor must account for. And then procedurally, the governor must create and share publicly an administrative record for each order. And there's also the same procedural requirement for the declaration. This requires essentially creating an administrative record. And for those of you who are thinking in terms of administrative law, you may be anticipating this means there could be a challenge where the record is insufficient or the record doesn't sufficiently establish that the governor has considered those factors or has rationally designed the order to achieve one of those goals. And if that's what you're anticipating, you're right on the ball. Another thing this statute does is address the rule order problem, essentially saying that public health emergency declarations and any public health orders resulting from them are subject to the procedural protections of the Public Health Emergency Authorities Act, but are not subject, they are not rules and they are not subject to rulemaking procedures under State Administrative Procedures Act to get at that particular problem. Now, renewing. One way in which new state statutes limit the authority of governors or executive branch officials to act during an emergency is to put a time limitation on declarations or on orders or both, and then not permit renewals or permit a limited number of renewals. We considered all of those and thought that the best practices are that the executive branch is in the best position to manage an emergency, and that there should be the governor should have the authority to be able to declare an emergency and redeclare or renew an emergency declaration to last according to the length of the emergency, as opposed to picking some arbitrary deadline. At the same time, to promote accountability and to recognize that things can change pretty significantly over time, the Act places a limitation. So declarations will expire, but renewals are possible. 90 days is the default that we set, but some may go to 30, 60, or 120. So the declaration itself will expire after 90 days unless it is renewed, and there's no limitation on the number of times the governor may renew a declaration. Orders then expire as soon as a declaration expires. So when a governor renews a declaration, it is also on the governor to renew the orders that otherwise would expire as well. If the declaration expires, the orders automatically expire. There is similarly no limitation on the number of times the governor can renew. However, renewals are subject to the same substantive standards that we saw on the two slides ago, and the same procedural safeguards. So the onus is on the governor to yet again state why the declaration why is there still a public health emergency, and what is the nature of the emergency, and then why each of the orders. And the governor must use the then available evidence. So a lot changed in the first 90 days. We learned a lot about COVID in the first 90 days, and the second 90 days, and the third 90 days. And so it's not enough for a governor just to take the same old record initially, or a renewed record. It is incumbent upon the governor to refresh that evidence. Now, that the old evidence may still be the best available, but likely there will be additional evidence as we go. And that would then likely change the nature of the orders that the governor would create as a result. Okay. We're going to return to some of this, but we're moving from securing public health emergency powers to the second goal of promoting accountability. See how it turned brown, the title? Oh, that's clever. So a declaration of a public health emergency at the time of both the declaration and each renewal must still be rationally based on the evidence then available to the governor about the nature of the emergency and its risks. And each public health emergency order at the time of both the initial order and each renewal must be designed to rationally reduce or mitigate some or all of the risks or effects of the emergency. And that has to be based upon the then available evidence. And remember, considering each of the 6 factors, well, the governor has to do that all over again. Why? Because the circumstances have changed, and how the relevance of those factors will likely have changed, and how they're balanced will likely change. Further, the governor's authority to renew a declaration of public health emergency is conditioned on the legislatures having an opportunity to be in session during at least the first 5 days of the term of the renewed declaration. This does not apply. So this is designed to trigger the political process, and this makes the most sense in states where 2 things are true. It's a part-time legislature, so they're not always in session. And as a matter of constitutional law, the legislature does not have the authority to call itself into special session. We ruled out the possibility of using legislative vetoes because our research showed that most states have a presentment requirement and don't permit legislative vetoes. And the only time legislatures can act unilaterally is when they're creating their own internal procedural rules for how legislation proceeds through the chambers. But we thought, how do we get the legislature more involved? We considered an option of requiring the governor to call a special session each time the public health emergency is renewed. That is an option. Governors can always call a special session if they'd like to. They can do so while the legislature is in session, or when the legislature is out of session. But special sessions are expensive. They can be politically fraught. And so we have decided to go with requiring that there is an opportunity for the legislature to be in session. Maybe they're already in session. Maybe they'll be coming back into session. Maybe they can call themselves into session. And if none of those things are true, that's when the governor has to make a decision. Do I let the declaration expire, wait a certain number of days and redeclare it, which is also an option under this Public Health Emergency Act, can wait. I think we set it at 10 days. Or do I exercise my authority as governor to call a special session so as to provide those 5 days and to then renew without there being any gap in the timeline of the public health emergency or the orders? That remains with the governor in the governor's discretion. But what we're seeing is that this triggers the political process. I think we started off by trying to legislate most of this in our model law and said, too much of this depends on, we have to be able to trust that the political process will be functional. If the state legislature is in place, the state legislature can pass bills and send them to the governor. And they may say, well, wait, the governor's got all this power, so of course the governor is going to veto them. No veto is without its political consequences. And they are subject to override. And we should let that political process work. And one of the reasons we should let it work is that a byproduct of a governor's wanting to veto, but not wanting to deal with the political consequences of vetoing a legislation that comes from the legislature, is that there would be conversation between those two branches of government. There would be negotiation. It might not happen in every case, but we see it as fostering that kind of negotiation, which is itself a procedure for good governance and the involvement of the legislative branch in a particularly lengthy emergency. Why did we not include a legislative veto? Well, here's this Pennsylvania case I promised, Wolf versus Scarnati. It arose during COVID. The governor, the COVID public health emergency was in place, declared by the governor. The state legislature, by concurrent resolution, terminated the public health emergency, and the governor sued, and it went to the state Supreme Court, and the majority held that the state's constitution did not authorize the state legislature to make binding law through a concurrent resolution or any other form of legislative resolution that does not include presenting for signature or veto the resulting resolution or bill to the governor. It did not, and so it was declared unconstitutional. Interestingly, at the next opportunity for a state election, there was a referendum to amend the Pennsylvania's constitution to permit concurrent resolutions for the purposes of ending an executive branch declared public health emergency, and it passed. So now it is legal, but it takes a constitutional change. The Uniform Law Commission is not suggesting a model constitutional provision. It doesn't do that work. It really just sticks to at the statutory level. And so we designed a statute that would account for the fact that most states have state constitutions that would be interpreted similarly to the way the Pennsylvania Supreme Court interpreted the then current Pennsylvania state constitution in this case. And then finally, this is where, if you were looking about that administrative record and administrative law challenges, this is one of the big tools in this statute. Any person withstanding, which would be any person in a state subject to any order during a public health emergency, can seek judicial review of the public health emergency, either the declaration or the order. And the court may grant relief where the governor has misinterpreted the law, committed one of the procedural errors in the that are required in the statute, or acted in an arbitrary or capricious manner, or the facts are not supported by substantial evidence in the record. This is a really good tool. And one of the things I like about this tool is that it gets us back to my triangle. And we're moving now to the channeling legal challenges. Right, it says, aim here. Here's a nice carved path with standards of administrative law that will be recognized by courts. And if as was complained of so often, that the orders are not based in evidence, or has failed to take into account important consideration, or there isn't a sufficient record that was made publicly available, whether it's for the declaration or for the orders, then that's where the individual standing can have success, but it leaves in place the authorizing statute. And you might say, well, that's horrible, that an order that might be necessary or declaration that might be necessary. If that's what happens, there's always the option of the governor going back under the authorizing statute to the starting place and redeclaring, and issuing new orders, but doing so in such a way that better accounts for the statutory requirements. So there's minimal delay. Meanwhile, though, if the value of channeling away from attacks, constitutional attacks on the authorizing statute, is that once the authorizing statute's gone or been narrowed, there's really no way for the executive branch to act in a way that protects public health during an emergency in an adequate way, and it leaves us unprepared for future emergencies. So I'm just describing here in words pretty much what I just said to you, except that I'll add what is in the last bullet point there, that this acts as a safety valve to reduce the likelihood of amending, repealing, or challenging the constitutionality of authorizing statutes. It's a way to let off the frustration, the steam that comes from this in a way that is legally valuable, and I think will tend to promote accountability and confidence that the checks on executive authority during a public health emergency make sense, and we're more likely to have that kind of confidence and better cooperation. So in the end, you might say, well, I'm going to tell you, all we're really doing with this is the house on the right, that foundation, that's what we thought we had pre-COVID. The house on the left, this is what we're discovering about the foundation of law during a public health emergency, that it sagged and in some states even broke. And all we're really doing is going back to the right side. We're going back to further securing that in place. It's a win now to be able to simply have the kinds of public health powers that we thought we had pre-COVID. And one of the reasons is this. Here's this ALEC legislation. Orders are subject to strict scrutiny. They have to literally be necessary. I'm not sure that with evidence that's available of us at the start of an emergency about a novel disease, a strict scrutiny could ever be satisfied. Orders must expire after 7 days if the legislature is in session, 30 unless they are ratified by the legislature. This does authorize a legislative veto. I think in most states that would be unconstitutional. And it prohibits the governor from reissuing an expired or terminated order during the same emergency. This is a recipe for simply not responding to emergencies for longer than 7 to 30 days, unless the legislature wants to manage an emergency. And what I tell people in Missouri is that we have floods all the time. Can you imagine if the Missouri state legislature was in charge of deciding who had to evacuate and who didn't, which levee we're going to put more bags against and which one we're going to blow up to let off some of the water and flood? You might think that the executive branch is not a great branch to handle an emergency, but you will as soon as you consider the other two branches. They're in worse shape to handle it. So that's the end of my presentation. I am happy to answer questions, and I will stop sharing my screen.
Thank you so much, Professor Gatter. That was excellent. So if you're online, please put your questions in the Q&A. We have somebody monitoring that. If you're in the room, please raise your hand. And let me just ask the first question. I believe you said that any citizen can go to court and challenge a declaration or an order. There seemed to have been, tens of thousands of people that were unhappy. Is that going to clog the court? How are you going to manage that degree of legislation, of litigation?
Yeah, I think the answer is it could potentially clog the courts, but I think what we'll see is similar to what we saw in this pandemic, which is that groups of people sue. That the lawyers representing an individual who's likely to sue is quick to find essentially a class. I don't think that it will literally be a class action, or courts will simply exercise their discretion to consolidate cases because they're raising exactly the same issues.
Okay, Mike, is there something online?
Yes, so I did have one question. Thank you for the talk, by the way. It was great.
Yeah.
So I have a question from Michael Morley that basically boils down to how should we deal with constitutional limits on public health powers and perceived inconsistent application of those powers, talking more about what would be seen as action by the governor that's not particularly consistent with church going versus protesting.
Yeah, and you'll notice that I didn't raise a number of the 1,100 state law cases that were raised, and some of them were raised at the federal level instead, raised either state or federal constitutional challenges with respect to the application of the application of social distancing orders to religious services and whether or not that violated the First Amendment religious freedom rights. I think, that doesn't change. Obviously, there's nothing that a state legislature can adopt that would change constitutional standards of review, nor does it change what counts as being fundamental liberty interests or the jurisprudence for how state courts or federal courts work their way through the scrutiny that's provided to those. So if someone is isolated and they're isolated in such a way as to violate their substantive or procedural due process rights, this statute doesn't change that whatsoever. If it does so in such a way as to trample on religious rights, this statute wouldn't change that whatsoever.
Thank you.
Anybody in the room? Mike, do you have another one?
I do have another one. This is more of a particular about the model legislation as to why 90 days was your sweet spot.
Yeah, I know. I don't know. I think the idea is that we had toyed with 60 and we decided to go with 90. What we do in a model law is to put that, if you read it, you'll see that that number is in brackets. And you can almost imagine that if it were online as a pull down, and it would probably list 30, 60, 90, 120 and let legislatures choose. It's not tied to the nature of any particular emergency because the idea of this statute is that it shouldn't just be about infectious agents. It could be about toxic agents. It could be about a variety of different kinds of emergencies that aren't necessarily even disease emergencies, but nonetheless public health emergencies. And so there's no magic public health number there. It's really a political question. How often we're balancing the ability of a governor to have time to respond to an emergency, to gather more information, and the burden procedurally that it places on the governor to renew every declaration and redo the entire procedure, the entire administrative record all over again, and to do so for each order then, because each order would expire when the declaration expires. So it was trying to balance those two things.
Yes.
Does the act give attempt to define what conditions would lead to a public health emergency?
Yeah, it does. And it's one of the things we've had a substantial debate about over time. I didn't include that in this slide, but I'd encourage you to review it. For those of you who are familiar with the 2001 model law that was developed, I think it was developed at Georgetown University Law Center largely by Larry Gost and his staff with a CDC as a funded CDC project. There's a definition of public health emergency, and the drafting committee began by presuming to use the structure of that model law, as well as some of its definitions, because about 40 states have adopted some part of that statute. And by the way, that model law is not without its controversy. There's plenty of controversy about that law. But I counted them up and I thought I found 35 or 36 states that had adopted the definition of public health emergency from that statute, or something very, very similar to it. So from our standpoint, the idea is we have to assume that whatever we would be proposing would be in addition to that. And it's good to be as consistent as possible, and familiarity is helpful. At the same time, we did tweak that definition. So right now, the definition is that an emergency exists when there is some sort of biological or toxic agent that increases the risk of either deaths or injuries to a substantial population, or that has already caused those things, or that is likely to deplete emergency response resources in such a way that it can create an emergency simply because it's used up our resources. It has eliminated, and it applies whether or not it doesn't, the model law in 2001 focused in on what caused. And we do not do that. It doesn't have to be as a result of bioterrorism. It certainly could be. It doesn't have to be as a result of a disaster, whether man-made or natural, but it could be. Instead, it focuses in on a toxin, or some other sort of agent that could cause harm to a substantial population. And the key is that while there may be things circulating all the time, is that we're seeing more injury or more death than would be reasonably otherwise expected. And that would be enough. But I encourage you to see that that's one of the most important definitions, because of course, the existence of the public health emergency is what authorizes the governor to declare the emergency. If the definition is not met, then the governor doesn't have the authority to just simply declare it.
Professor Melman.
I don't, Rob, great talk. I don't know if we have time for this, but a aggrieved citizen goes to court to try to block the measures. The court issues a temporary restraining order, right? Does the governor under the act have any ability to act in the face of that? I mean, remember, the whole idea of emergency powers is it's an emergency. You got to do something. And if you have some, well, that's my question.
Yeah. So if this has happened, so we had a conversation about whether or not we have to lay out what kinds of authority the court has, and we decided that that would be dumb because that's already established in the law. So we're imagining a couple of different ways this could go. It could be temporarily halted for the sake of a larger hearing. It could be permanently halted on the grounds that either the record was insufficient to know whether or not the governor's order was rationally related to one of those goals, or it could be as a result of the record failing to establish that the procedural requirements were met and were met on a timely basis. The other option for the judiciary is that they have the discretion to limit the order to some parts of an order, or to give a certain amount of time to the governor to supplement the record before and then to consider that before they enjoin the order as a result of the emergency. So the act simply defers to the existing discretion of a judge to take action in a way that makes sense for the particularities of the case. If a court were to go so far as to completely enjoin the order, it's most likely because the governor has made a mistake along the way. Either the order is irrational and it should be enjoined, or the governor has failed to consider the factors on a timely basis, meet the procedural requirements on a timely basis, release the record on a timely basis. So the governor may have good reasons, but has failed to put it in a report on a timely basis. If that's the case, the governor always has the option of essentially going back to recreating that record, and then reissuing the order. There's no limitation as there is under some of these rollback statutes on the ability of the governor to do a do-over with a better record. So in that way, it's very similar to the way administrative law works on all of this, where an agency issues an order and they've done so in such a way that fails to meet their statutory, procedural, or substantive requirements. The order can be set aside, but it doesn't stop the agency from reissuing the order, this time without making those same mistakes.
Well, thank you so much. We're going to have to stop. We really appreciate your insights and have a good afternoon, everyone.
Thank you. Completely my pleasure. Thanks everybody for the invite.
Second or something?
Yeah, I don't know. You can contact. Cases that are finding in favor of.
Well, I'm not gonna lawyer. That would create a hurdle for the governor to prove the, that's and so forth. That would be very, that would give courts a very easy way of executing law. Yeah, I say. But what I was getting at, yes, I mean, the judges have that authority.